Restrictive covenants such as non-compete clauses, non-solicitation clauses are different in terms of the enforceability of those clauses from state to state. So you really have to take a hard look at that. And if you're based in one state like Florida, but you have employees in other states, you need to also understand the rules of the state in which that employee works. So you may have satellite offices, so you really have to take a look at every state that you're going to be employing people in. In Florida, for example, it does enforce non-compete clauses and non-solicitation clauses. They are required to be reasonable. If they're not reasonable, meaning they're too broad geographically, they're too long in duration, more than 2 years, for example, the courts have the ability to, instead of throwing them out, to actually whittle them down in terms of geographical scope and duration. And so they'll still be enforceable because a court can just make them more narrow. In other states, they're completely void against public policy. They're not enforceable at all. Or the courts will say, well, I'm sorry, I could have enforced it, but you've been so unreasonable in your demands as how broad this is that I have to throw it out. They can't whittle it down as they can in Florida. So it does vary from state to state, but most states do enforce them to some degree.